everyone. Welcome to our Global Investor Forum. I'm Monica Young. I am the broker of Just Global Inc. and the host of the GREI Club. And today's presentation, we're going to have two different sections. In the first section, that I'm going to give you a brief market update, and then followed by our feature presentation by Mrs. Simon Offord to talk about the legal consideration when selling a property. Next. So just to share with you the Santa Clara County and San Mateo County status. And as you might have noticed, that Santa Clara County actually have very strong growth. Year to year is like 10.1%, and with a median home price of 1.49 million. And in terms of like home sales, it's almost like 24% higher. And yet the active listing have fallen down by 23%. So that leads to a bidding war up to like 105.1%. So you can see that the market's definitely moving very, very rapidly. We've seen like multiple offers all the time, especially with the low interest rate. Next. So the Mid-Peninsula is even more competitive. You can see that median home price also has gone up by 20% to 1.9 million. And home sales also edge up about like 12.3%. And yet inventory has fallen by 16.1%. And if you put a property in the market, it will be pending within about 9 days. And the bidding price is about 103%. So you always have to overbid. So we've seen that even the pandemic's still going on, there's still, very, very active real estate market. Next. As you might have heard and learned from our event about Proposition 19. So very important date coming up, which is April 15th. And with the passing of Proposition 19, homeowners who are 55 and over, severely disabled, or those homes that's been destroyed by wildfire, they would be able to transfer the primary residence property tax base to a replacement residence of any value and anywhere in the state. So that means, like, say, used to be Proposition 60 and 90, you can trade up to 105%. But after April 15th, provided that your property closed after that day, you can either trade up or trade down. So if you trade up, you pay the difference. Say if you sell it $1 million, you bought like 2 million, then you keep the original tax base, and then you pay the difference of $1 million. So you can buy first, sell first within a 2-year timeline. So that we notice that a lot of people are trying to buy and sell because of the Proposition 19. So I hope that would be able to help the increase of inventory. Next. So if you are selling a property, I'm sure that you would be interviewing real estate professional instead of trying to sell it yourself, because a home can be one of the biggest sale and purchase in your lifetime. So it's very important to find a good professional to help with your sale. So basically, there are 8 aspects that we would suggest you to consider. First of all, many home buyers, I would say about like 39% of the purchase now is first-time home buyer, but of course there are other trade-up buyers. So they want to buy a home that is move-in ready. So having some turnkey solution and with good home improvement is very important in order to sell fast and also at a good price. Also, you need somebody who are very well versed about the market, local activities, the trend, and also have all the information and data on hand so that you can really nicely price your home strategically and get maximum exposure. At the same time, an experienced agent would be able to get you good negotiation process and take care of all the miscellaneous things that come up maybe during the inspection or the appraisal, and they would have experience to deal through all those challenges. At the same time, one very important point that I want to highlight is about seller disclosure. And that's why I invited Mrs. Simon Offord today, because seller disclosure is very important. Even if you sold a home, but then if you don't have proper disclosure, it's going to haunt you, even years away. So it's very important to get a professional agent to assist you through the process and disclose everything you know about the property. And also having an experienced agent would help to manage contract and transaction details. And so you have a very smooth transaction. Next. These are the aspects of seller disclosure, but of course it's not like a very comprehensive list. That's we want to listen to Simon about his comments. But very common is you definitely need to disclose information about death in the home, any neighborhood noises, hazards in the home, and also any kind of like say flood zone information about like the actual zoning of the property. And if you have a homeowner association, so HOA, either, even single home now could have HOA, and also like condo, townhome, it's very important that you have to really get all the information. Like sometimes, I just encountered a situation that we got into purchase and the seller really want non-contingent offer, but then the HOA docs have not been ordered in advance. So when a buyer writing offers, they kind of like concerned whether there've been like litigation or any other occupant issues that, have been, that have like issues. And at the same time, you want to make sure that you would have all the information about repair that you would disclose. And if there's anything that's missing in the house, then you have to disclose it. And most important of all is about the compliance, because sometimes, people would convert garage or add a unit without permit. All those you have to disclose in advance. So the rest I will leave Simon to elaborate. We like to share with you our upcoming listing. So we do have an active listing that is a duplex in Menlo Park. It is very, very well priced, with a 4.11% cap and a very, very attractive cap for Bay Area, asking for $1.25 million, and it collects $6,050 for rent per month. It's a 3-1 plus a 2-1, and very close to Facebook. If anybody is interested, contact us. Next. So this is coming up. It is a Cupertino school home in San Jose with 1,353 square feet, and the lot is about 4,000, and the price is going to be determined. And we noticed that both Sunnyvale and Cupertino homes are very, very active, and most of the price actually have an overbid about anywhere from 110 to 111%. It's very, very active market. So this one is going to be coming up in 2 weeks, being remodeled. It's a very big home. We noticed that during the pandemic time, a lot of people are working remotely from work. So having like a home in the suburb, give you like more bangs for the bucks. So 2,700 square feet and with a big lot, newer home. And I think the price is going to be between $550,000 to $575,000. So if any interest, contact us. And Lathrop is about 10 minutes north of Tracy. Next. So this one actually is 2 units in South San Francisco, Daly City area. And because the tenant is the process moving out, so we would be able to get complete vacay units by end of April, early May. And so this is under $1 million. And if you are interested, also let us know, like we can talk about it even off market. Next. So this one is tenant occupied, but the tenant's moving out end of April, and then we will have some remodeling done. So we expect this going to be on the market by May, and it is very close to the Sierra, North San Jose area, a very quiet condo style townhome, and the price is going to be around about like between mid 800 to high 800,000. Next one. So this one is in San Jose, Evergreen area, and the seller is still preparing for the home. But then we noticed that homes with good schools are very high in demand. And this one actually has been expanded, very nice, updated remodeling. So if you are interested, let us know. We would be able to also reach out to the seller if you are interested in off-market transactions. So you know that we've been marketing Austin. So Austin is a very, very active market. And this particular multiplexes is going to be, I think, is high demand, you know, because like right now, like Austin's been going through bidding war, anywhere from 20 to even 90 offers. So to have something off market, I think is interesting. The only thing is, it's a pretty big puzzle. We're trying to talk to some of the investors. They might want to join force together. So it's 13 fourplexes and 1 duplex, and it's fully occupied. It was built in 2017, and they were asking for $9 million. So we also talking to commercial lenders about, you know, the LTV, you know, the loan to value in terms of like how much you have to put down. But anybody who are interested, especially if you have a group of friends who are interested to buy fourplexes together, and this is only 4 years new fourplex, very close to the tech corridor. In Austin is about 25 minutes away. Let us know. This is in Liberty Hill.
54 units apartment.
54 units, yeah. 13 fourplexes and 1 duplex. Yeah, and we have to double check on about financing. It's about 4.6% cap. Yeah, pretty good cap. I think at the back end we can sell about like maybe about 800,000 per unit. Right now it's about like 670,000 per fourplex. Okay, so next one. So I'm Monica. I am the broker of Just Global, and we have associate broker Carl, and also we have other team members that are supporting, so you know us. If there's any question about what we have presented, let us know, and we'll be happy to address your real estate needs and questions. So that finish up with my update, and we're going to have the second part of feature presentation by Mr. Simon Offord. Simon graduated from the UC Santa Barbara in 2005, and he got his doctorate from Santa Clara U in 2009. And he is a member of the Santa Clara Bar County. He's a member of the, he's definitely, you know, very active in Bar Association. And in the past few years, Simon has worked on matters representing real estate professionals and homeowners involving neighbor and property disputes, and also a lot of commercial leases been working on. So please let us welcome Simon. Simon, you have the floor.
Great. Thank you very much, Monica.
Thank you.
Thank you for that introduction. You've hit on some of the things that I want to talk about today. And so just in general, I'll give everyone a sense of what's been going on in the real estate legal world during the pandemic. Our office has been doing a lot of work dealing with commercial lease issues, navigating all the different eviction moratoriums that exist, because each city and county is different in terms of how they're dealing with commercial eviction moratoriums and whether landlords can evict their tenants. And it's dependent on the county and the city you're in, the size of the business of the tenant. If it's a small business versus a big corporation, there might be different rules depending on where you are. And then most of these moratoriums are providing the tenants an opportunity to not be evicted for not paying rent during the pandemic. And then they have set amounts of time to repay the unpaid rent. So in San Francisco, for instance, there's different amounts of time that the tenants have to pay the unpaid rent back, depending on the size of their business. And so for commercial tenants, it's been a tough time because they're not necessarily getting rent and they're having to figure out what eviction moratorium applies to them and all that. So there's a lot of negotiation that's going on, and workouts or maybe even buyouts on leases. I'm working on a couple buyouts right now where the tenants are just paying to get out of what might be another 5 years on their lease or something like that. So we're seeing a lot of that right now. We're also doing a lot of neighbor disputes. It seems like when everyone's home more often, they start to get more bothered by maybe the noises their neighbor's making, or the tree that's impacting them. Or even I had a client recently that the neighbor put on solar panels, and there was a really bad glare coming into their house. Because people are home all the time, they're noticing these things a little bit more, and unfortunately we're seeing more neighbor disputes because of that. But otherwise, business is as usual. The courts are starting to slowly open up a little bit more. So there was a time where kind of nothing was happening in cases because the courts are mostly closed, but they're slowly starting to come back to life. But I will tell you, if you're in a real estate dispute or any dispute right now, the courts they were backed up before the pandemic. They're even more backed up now. Getting matters to trial is going to take in the range of years, as opposed to you'd like to get to trial in a year or so. That's not going to happen. It's going to be 2 to 3 years to get any case to trial, unless it's like some sort of eviction action. So moving to the topic at hand, we're going to talk a little bit today about dealing with selling your property, legal considerations and concerns there. And really the biggest issue that I'm going to talk about today is just disclosures and trying to avoid getting sued on the back end. There's a whole nother topic for a whole nother day about transactional disputes, what can happen during the transaction, but I'm not going to talk about that today. I'm just going to talk about the disclosure side. So as Monica mentioned, a lot of times nowadays, especially in the Bay Area, this isn't necessarily true outside the Bay Area, but in the Bay Area, people want to have non-contingent offers. And so in order to do a non-contingent offer, you have to have your disclosures ready before the property is listed. And so what does this mean? It really means that sellers working with their agent need to be doing their homework before they get the property listed. So this means they need to be spending time to prepare the disclosures in advance. And this is critical. The disclosures are not the time to market the property. Disclosures are the time to protect yourself from getting sued. So you've really got to spend time going through these disclosures and thinking about everything. The forms that we have with the California Association of Realtors, or if you're on the peninsula, you might use the PRDS forms. They've been created for a reason, and they've been changed and supplemented over the years by real estate attorneys who work on these committees, because those forms and those questions on those forms are things that we've seen lawsuits about. So we've got the transfer disclosure statement and the supplemental questionnaire. There's a lot of questions on those, but those questions are there because someone has sued someone else about that question. And so it's very important to go through every single question and think about your answers. I speak to real estate agents a lot. I go to brokerages and I go to the local real estate associations, and I always tell my brokers and my broker clients, if someone asks you, should I disclose this? The answer is going to be yes, pretty much 100% of the time. Because if the seller is thinking, hey, is this something that's important? That means it's probably important and needs to be disclosed. So when you're filling those questions out, the way the forms are set up, it says, has there been any remodels without permits? And it says yes or no. You don't want to just check the box that says yes and not explain. So what we see a lot of times is people do disclosures, and if there's a question that they answer yes to, they then don't go on to explain it. That's a problem, because if the buyer then doesn't follow up and ask, we've got a potential non-disclosure issue here. So when you're saying yes to any of these questions, you really have to explain why you're saying yes. Are there any water issues in the property? If you just check the box yes and don't explain that the roof has been leaking for the last few years, you're looking like you're going to probably get sued if you don't actually explain why you said yes. So you've got to go through the forms, and don't feel like you're married to the forms, meaning if you need to explain something, hey, there's been a history of these water leaks or whatever it might be, you need to put into the form what that is. And the way the forms are set up, there's only a couple lines in each section. So if it doesn't fit, feel free to add an additional explanation of what's going on. And funnily enough, a lot of times we see these cases where someone just missed the question. And what oftentimes seems to have happened is the client or the seller didn't really know how they should answer the question, and then they just forget to go back to it. So once you finish, go through and double check and make sure you've answered every question there is. And if you have questions about how you should be answering something, you need to discuss that with your realtor or your attorney to make sure you're covering yourself. The other thing that's important is to actually provide documentation. So if, for instance, you had to do a roof repair, provide some backup to show who it was that did the work, especially if it's something substantial. That way, the buyer can't say, well, I had no idea that it was this big of a deal and it was a $20,000 project. No one told me that. Well, if you give them the invoice, they have the information. If they have questions about it, they're free to investigate further or call the contractor or do whatever. So from a liability perspective, more information is always better. Now, I want to talk about some of the most common types of disclosure issues we see. Monica had a pretty good list there, and I've put these in somewhat rough order of where we see them. So one of the biggest ones are water damage issues. Water is always a problem, it seems. And so what we see a lot of times is someone has had a historical roof leak or water penetrating in from some portion of the property on the walls or something like that. And the seller fixes it, or at least they think they've fixed it. So they hire someone to come out, a handyman, a contractor, whatever. They patch the roof, and then they don't see any more water coming in, and they think the thing is not a problem anymore. It's resolved, and so they leave it and they then sell the property, and they don't disclose the fact that they had a prior water issue, because in their mind they think, well, there isn't a water issue anymore because I hired this handyman that I love and he does a great job and I haven't seen any more water coming in. That's a big area of concern. The reason being, with the way water is and the way gravity works, water issues, even if you fix the source of the leak, there might still be water that has gotten inside the property, in between the walls. You might have mold growth starting, or you might just not be seeing the water coming in anymore because maybe instead of it dripping into the room, it's actually just being diverted and going in between the walls or something like that. And then when the buyer purchases the property and they pull out the drywall and there's a whole bunch of dry rot behind, they're going to say, no one told us that there was this history of water leaks. And so this is a really, really critical issue that we have seen tons of lawsuits on this about. And so if there has been a history of water problems, just because you think they've maybe been fixed or repaired, you still need to disclose that in the past there were issues. And then at that point, then it's the buyer's responsibility to ask questions or to look into it further. You've given them the information and then they need to go ahead and try to verify it. And so one pet peeve I have is people might say, okay, the worst case scenario is people don't say anything about the prior water issues. The next worst case scenario is an improvement, but it's still not perfect. Sometimes people will say, we had a roof leak and it was repaired, or we had a roof leak and it was fixed. Okay, when you say that, that is suggesting that it's not a problem anymore. So what are you doing? Well, you're in effect guaranteeing the work of whoever you hired to fix that problem. Because if you're saying it's fixed or repaired, that there's a connotation or a suggestion there that it's not going to be a problem anymore. And if whoever fixed the roof didn't do a good job, And then when the next rain comes, it starts leaking again. The buyer is going to come back to you and say, you told me this was fixed, but it's not. It's still leaking. And now I have to put a whole new roof on. So the way you word things is very important. So instead of saying something has been fixed, you want to say more like work has been done or repairs done. And then you just give them the invoice or whatever documentation you have. And then at that point, again, it's on the buyers to figure out, well, did they really do a proper fix or not? But you've given them all the information you know. What we want to avoid is you essentially guaranteeing the work of whoever you hired. And so I have a good case example of a case like this that I worked on, where we had a client who had a property in South San Francisco. It was a rental property. So the landlord, and the landlord actually didn't live in the Bay Area, so he wasn't around much, but he knew that his tenants had complained a few times about water issues. And so he sent out a handyman, and the handyman was patching these stucco cracks on the exterior of the property. And he disclosed that he had patched stucco repairs on the exterior of the property due to water intrusion. So good. What he didn't say was, I had to do it, every 2 years because it kept coming back. So his disclosure was, not all the way as good as I'd like to see it, but he at least told them that they had been past water issues and he'd been sealing them in the past and all that. So you can understand what kind of problems this causes, though. The buyers of this property purchased the property, and they started pulling off all the drywall because they wanted to do a pretty extensive remodel. It ended up being that when they pulled off the drywall, all these stucco cracks that had been letting water in over the years ended up being a pretty big problem. They had about $300,000 in dry rot damage. Basically, all of the interior wood had been damaged from this long history of water getting in. And so obviously the buyers weren't happy there. And they sued my client, the seller. We ended up winning the case because he had disclosed these things. He didn't do the best job I'd ever seen on the disclosures, but he at least mentioned that there have been water issues. The buyer's concern or the buyer's claim was, you didn't tell us that this had been a long-standing problem, that you had to keep refixing it every couple of years. You had just made this fairly vanilla statement that some water issues and stucco cracks were repaired, was basically what he had said. And so although we won the case because we pointed out that they didn't ask up any follow-up questions, and there's all these places in the disclosures where it talks about the duty of the buyer to do their own investigation and all that. And so we won the case, but this was a long dispute that our client had to deal with. He ended up winning. His attorney's fees and the arbitration expenses were over $100,000. But again, because we won, he got a judgment against the buyers for that $100,000 in attorney's fees. But it was not certainly something that he would want to do again. It was a stressful, long process. And even though he won, it's not something any seller wants to get involved in. And so had he been more forthright and explained the situation more, it would be unlikely that the buyer would have any even inclination to go after him, because the way he disclosed it was a bit thin, to say it another way. It gave the buyer enough motivation to try to go after him because they felt like he had tried to mislead them. So water damage is just something we really, really need to be careful about and how we disclose it. Next big issue we see are permitting and remodel issues. There's specific questions in the disclosure forms about how you handle, or has there been any remodeling and has everything been done with permits? Despite the fact that there's a very straightforward question that asks that, it's shocking to me how many people fail to tell the buyers that they did some sort of remodeling. If you did a remodel without permits, so be it. Disclose it. That's what the disclosures are for, is to keep you out of trouble. It's not like if you disclose that, the county's going to find out about it and come running down and red tag you. Theoretically, it's possible if someone tells the county, but it's more important that you avoid getting sued for not disclosing that you did some sort of work without permits. And a lot of times this has to do with electrical or plumbing issues. If you just have a handyman come in and rework your electrical system, you've got to disclose that it's not permitted, because that can be a really big sticking issue. Another one we see all the time are square footage issues. And this is a tricky one, because square footage is kind of a unique beast in that, depending on who you ask, you might get a different answer. So when a property gets listed, the square footage that might pull up on the MLS, the multiple listing service, is usually going to be the square footage that the county says. But maybe at some point you've gotten an appraisal done of your property, and the appraiser comes up with a slightly different square footage. And then at some other time, maybe you have some report from somewhere else and you've got a different square footage on there. And when we're paying the kind of prices we are for property in the Bay Area, the difference of a couple hundred square feet is thousands and thousands and thousands of dollars, right? People are paying exorbitant fees. And so if they feel like they're shorted a couple hundred square feet, they might be suing. So the best way to deal with the square footage issue is a couple things. One, you have to disclaim where the information is coming from. So if you're saying in your disclosures, the house is 2,000 square feet, you want to say per so-and-so's appraisal or per county records. So you're disclaiming, saying, I don't necessarily know this myself. This is just what such and such report or such record tells me. And then the buyer can look at that and compare it to whatever other information is out there. So it's always good to disclaim and cite the source of where you're getting the information. And if you have multiple reports that have different square footages on them, disclose that. You've got the appraisal that says 2,000, you've got the county records that say 1,800, and then you've got a blueprint from your architect that says 2,100. Let all that information be known, and then so the buyer can try to verify which one is accurate. It's not really your job to do that, to figure out which one is right or wrong. It's just your job to disclose what you know. There's also a form that your realtor can include in the transaction that basically explains that square footage needs to be verified, and any representations about square footage aren't necessarily accurate, and that the buyers should be confirming that themselves. So the square footage one is important. And the biggest takeaway is to disclaim and to disclose all the sources of the square footage that you've got. Another big one we see are homeowners association issues. So as Monica mentioned, the homeowners association itself puts together a package of what needs to be disclosed. However, homeowners associations aren't always the most organized groups. And so you as the seller want to double check and make sure that everything is actually getting into the homeowners association disclosure packages. We've had a couple situations where sellers have sold property, and then the buyers, a couple months after closing escrow, find out that the homeowners association has some massive special assessment that's coming because, for instance, all the decks or balconies in the whole association need to be replaced. And it's a $50,000 assessment that every homeowner has to pay these costs to fix all the decks or whatever it might be. And the buyer says, no one told me this was coming. So in one of those scenarios, the homeowners association had sent out a letter to all the homeowners saying, basically, we have to do this deck repair. We're looking at bids, but the estimate is going to be that it's going to be between $30,000 and $60,000 per home. And that letter didn't get disclosed to the buyers, and the homeowners association didn't get that letter in the package. And then so the buyers unsurprisingly sued the sellers, saying you had specific knowledge that there was a special assessment coming. Yes, it hadn't been voted on, or the exact amount wasn't known yet, but you knew that there was a problem and you didn't disclose it. And that's a real liability there for a seller. And so, you've got to rely on the homeowners association to do stuff right, but you also, if you have specific knowledge yourself, you need to disclose it. So like, there are some instances where maybe there are message boards that you're active on in the homeowners association as a seller. And if there's discussion in the message boards about, the homeowners wanting to vote to get rid of units being allowed to have hardwood floors, which is a big issue that's going on right now, or some sort of limitation on the ability to rent out the units in the homeowners association, either by way of a short-term rental Airbnb type thing, or just in general that there's a cap on how many rental units are allowed in the HOA. And that discussion is known to you, that that's something that's going to be voted on, and you don't disclose it. Again, that's a potential exposure, because if you had specific knowledge by way of your involvement in the HOA or these message boards, and you have emails or something to that effect, that could come back to bite you. So homeowners associations have a whole slew of additional things to be concerned about that should be disclosed. At the beginning, I mentioned all the neighbor issues that we're seeing right now in litigation and neighbors disputing with one another. Well, this is also something that obviously needs to be disclosed. So if you've got a neighbor that's got a tree that's causing damage to your property, or vice versa, you've got to disclose that, because if the buyer purchases the property and then the neighbor says, you've got to remove that tree, it's causing my foundation damage, and the seller didn't disclose that, that's going to be a problem. We've had some extreme examples where, for instance, in one situation, a buyer purchased the property and the neighbor started harassing them immediately. The seller had actually filed a restraining order against the neighbor because he was just a wacko, for lack of a better way to put it, and he would harass everybody that he came in contact with. Well, to get a restraining order, you've got to file papers in court, and the buyers found the declarations that the sellers had made saying that this guy comes over and bangs on our door and yells at our kids and does all these crazy things. And it was horrifying, some of the things that this guy was doing. And it was in public documents where they had said he'd done all these things, but they didn't disclose it. So the buyers purchased the property, and now they've got a psycho living next to them that's scaring their children and all that. And it wasn't disclosed. So that's an extreme example. But disputes with neighbors can get messy. And so if there is some issue where maybe the fence is not perfectly on the property line, or again, a tree issue or noise issues, those things really need to make sure that they're getting into the disclosures. And the last thing that I would say is on the most common things we see are title issues. So when you sell a property, the title company is supposed to put together the title package and the preliminary report, which identifies easements and if you're in a homeowners association, maybe what parking space you have the rights to and all that. So you as the seller, understandably, are expecting that the title company is going to do a good job and catch everything. But sometimes the title company misses things or maybe states things inaccurately. For instance, I've seen many times the title report not have the proper parking spaces, or there's some inconsistency between the parking space that the title report says the condo owner has a right to, or maybe the number of parking spaces the condo owner has a right to. But in practice, the condo owner has been using more spaces all this time, thinking that they had more spaces, and they disclose that they have 2 spaces when actually the title report only says they have 1. So as the seller, you should be double checking and reviewing the preliminary report to make sure that all the easements and parking issues that you're aware of are actually contained in that report. Because if that isn't disclosed, or if there's an inconsistency there, again, a buyer might be upset and come after the seller and sue them for that. And so that's an issue where maybe there's title insurance if the title company made a mistake, but still, if you as the seller can avoid any potential liability, it's always better to fix and clean those things up before you get the property listed and sold. And so those are the most common issues. Now, what does this all mean? If you fail to disclose something, what happens next? Well, most of us are going to be using the California Association of Realtors form when we are doing a sale. And so the California Association of Realtors form has a mandatory mediation provision. And so if a buyer buys a property and as soon as they move in, they start having water leaks, they can't just immediately run to court and sue the seller. Instead, they have to go through this process of mediation. There are some limited exceptions to mediation. If the amount of damages are less than $10,000, you don't have to mediate. If there's some emergency relief that's needed, you don't have to mediate. But in general, most of these disputes go to mediation. And so mediation is a process by which the parties meet with a mediator. These days it's happening via Zoom, but in the olden days, and as we hopefully get out of COVID, they will be in person. And the mediator is an independent, unbiased party, and his or her job is to simply try to broker or negotiate a settlement. And so the mediator is going to get the story from both sides and go between the parties and try to understand their positions and come to some sort of agreement. Now, mediation only resolves the case if the parties actually agree to some settlement. So, seller, I'm paying the buyer $20,000 and we're done. Then the case is done at that point if there's a settlement. If there is no settlement and the parties don't agree on anything, then the buyer has to decide if they're actually going to take the next step, which is to file a lawsuit. And a lawsuit, the California Association of Realtors form has a section that deals with dispute resolution, and it's an optional section to decide if you're going to arbitrate disputes, or if not, then you get to go to court. And so a lot of times people initial the arbitration section, which means that instead of filing a lawsuit in Santa Clara County, you arbitrate the matter. And an arbitration is a matter in which a retired judge or an experienced attorney basically acts as a private judge. And it's a more expedited process typically, where both sides put on their cases and the arbitrator makes a decision at the end and it's binding. And the interesting thing about arbitration is it's not appealable. So even if the arbitrator gets the law wrong, whatever the arbitrator decides is the final determination. And so when you're selling or buying a property, you've got to think hard about whether you want to agree to the arbitration provision or not, because some people seem to think that it's required that you sign that section, but it's not. It's an optional provision that only takes place if both parties actually initial the arbitration clause. And so, mediation is a process that typically costs anywhere between $4,000 to $8,000. So it's not cheap because you're paying an attorney for a whole day of mediating. You have to split the cost of the mediator. And so even if you feel like you have no liability, if you do something that causes the buyer to be upset and they want to mediate, you're going to be coming out of pocket. And so that's why it's really, really, really important to understand that let's do the best job we can in the disclosures, because even if you're in the right, if you just say something in such a way that makes the buyer feel like they're being misled, the cost to resolve these disputes is significant. Most of these cases settle. There's the expense of litigating or arbitrating these cases is substantial. So most cases settle in these mediation stages, but you're never going to be happy if you have to go through the process. So you've really got to do the best job you can to try to disclose everything and disclose it as best you can. And if you disclose something orally, or your agent discloses something orally, always make sure that gets followed up with something in writing, because people tend to forget. If it's not in writing, it's hard to prove. So we've got to be very careful that if something comes up during the transaction and there's a question asked and you give an answer, make sure it's backed up in writing, so you can always point back and say, no, Mr. or Mrs. Buyer, we told you this, here's the email to prove it. And so I see some questions. Monica, should we dive into the questions now? I've been talking for a long time, so if anyone wants to jump in, I'm happy to answer some of these.
Right. Yeah, sure. I think one of the attendee, Gina, have inquired, like say on the contract, the car contract, it always said the property is sold as is. So if with that statement, Does it offer any protection to the seller?
Yeah, so it's a good question, and it's a very misunderstood situation. So selling it as is does not mean you're relieved of your disclosure duties. Selling it as is simply means that you're not agreeing to do any fixes or repairs. So if during the disclosure process, someone finds out that there's termite damage, you're just saying, we're not agreeing to fix that. So an as-is sale absolutely does not relieve you of the requirement to make full and adequate disclosures. And the law specifically requires you to disclose anything that materially impacts the value or desirability of the property. So you've still got to disclose whether it's as is. The other question we get a lot that's similar to that is there are certain times under the law where you don't have to do the transfer disclosure statement, which is a form that's prepared by the legislature that has a bunch of questions about the property. For instance, if someone's selling the property as part of a probate sale, like they've inherited the property, you technically don't need to do a transfer disclosure statement. But that, again, doesn't mean you don't have to disclose things you know. So under the law, there's the statutory duty to disclose, which is the transfer disclosure statement, which is not always required, but there's also what's called the common law duty to disclose. And the common law duty to disclose means, very simply, if you know something about the property that materially impacts the value or desirability, you have to disclose it. So the situation we see a lot of times is maybe a child inherits the property from their parents, the parents die, and they're selling the property as part of winding down the parents' estate. And so technically they don't have to do a transfer disclosure statement because it's some sort of trust or probate sale. But, you know, they would go over to mom and dad's house all the time, and mom and dad would complain about how the roof's been leaking for years. So they know that. So just because they don't have to do the transfer disclosure statement doesn't mean they don't have to tell the buyers that there's a roof leak issue. So they still have to disclose it, even though they're exempt from the disclosure requirements under the statute. And proving whether they knew it or not might be a little more difficult. But at the end of the day, again, the critical thing is if you're selling property and you know something, as is, no TDS required, no matter what, you still got to disclose it.
Got it. Yeah, agree.
Monica, may I ask a question?
Yes, go ahead.
Okay, Simon, thank you very much for this seminar. I learned a lot. I have this question. If the seller inherit the property, doesn't have a disclosed package, and I bought that property, and I flip that property, then when I sell that property, what do I need? I will need to disclose anything I know about the property, but I don't know some potential or historic information about the property. So in my disclosed package, I only answer the question I know. The rest part I just know. I just answer don't know. Is that right?
Yeah, if you don't know, you don't know. You know, you can't control information that's outside of your knowledge. So if you bought the property and there were no disclosures made to you, and then you sold it a year later, you can only disclose the things you've learned in the last year of owning the property or anything that was told to you when you purchased the property. So I think that sometimes it is helpful to explain that in the disclosures, to say, you know, seller has only owned the property for 1 year, and these disclosures are based on what they know from their ownership, because that kind of puts the buyer on notice that, okay, well, they might not know much because they've only owned it a little bit, and that's helpful if something does pop up, because in flipping properties, you do get a lot of non-disclosure claims because that exact reason. You might not know very much about the property. So it is helpful to kind of give that little kicker that you know, our knowledge is limited because we've only owned this property for X number of months or whatever it might be. And so that's the best you can do, is disclose what you know. It is a good idea, if you have the disclosures from when you purchased it, to give those over as part of your sale, though. And I know you're saying that you might not have them in that situation, but I had an example where some sellers that I represented had sold their property, and they'd owned it for quite a long time, something like 8 years. But when they had bought it, there was a list of things that the seller to them had told them, that repairs and things like that were done without permits. And this was a property that was up in Portola Valley, and it was on stilts. And some of the things they had said were unpermitted repairs that had been done to some of the foundational stilts on the property. So it's a big deal. And they had just kind of forgotten all about that, because they'd lived there and they never had any problems. They just disclosed what they knew. Well, when they sold the property, they said to the buyers, oh, hey, by the way, there's a box of old documents that we have from when we purchased the property. We're just going to leave it in the closet and you guys can have it. Well, the buyers moved in. One day they started going through these documents, and they found this list of all these unpermitted things that had been done on the property. And then they were going to do their own remodel. And then they found out that there was some fairly serious structural issues with the property to do with these stilts. And they said, had you given us these disclosures that you had in your closet, we would have been able to look into this, but we had no idea. So we didn't know. And that became a pretty significant lawsuit, because the cost to deal with some of this foundation repair was in the hundreds of thousands of dollars. And so had they just given over all these documents before close of escrow, they would have been protected, but they, basically forgot about it and they didn't give it over. So that's an important thing to consider. And I did want to make one more point, just to clarify. The damages in these cases are not necessarily the cost to repair the issue. Instead, the true measure of damages is the difference between what was disclosed and what was actually received. So in these cases, an appraiser has to look at it and say, okay, this property in perfect condition was worth $1 million, but this property, without disclosing these foundational issues, was actually only worth $900,000. It's not necessarily, it's $200,000 to fix it. That's what the damages are. The damages is typically going to be looked at as a difference in value of what was actually received versus what was given.
May I have a build-on question? Is there a statute of limitation for this type of liability, this type of lawsuit?
Yeah, so in general, there's different statutes that apply to these cases because there's different theories that the plaintiff can bring. So there's a 4-year statute of limitation for a written contract. So that's really on the long end, because negligence and fraud are typically, depending on the nature of the claim, a 2 or a 3-year statute of limitation. But because the duty to disclose is actually built into the contract, there can be up to 4 years that a buyer can theoretically bring a lawsuit. The caveat to that is also, if there's some sort of latent defect or something that a buyer would not reasonably be able to discover, the statute of limitations doesn't necessarily start until they discover the issue. So in most cases, you're thinking 4 years is the long end of it. But if there was something that was hidden that they legitimately didn't have a way to learn of it in advance, then the time can start from when they actually discover the issue.
In your example, it's 8 years is still suitable, right? The foundation still problem. It's 8 years, right?
No, the statute of limitations for breach of contract is 4 years.
Okay. If I didn't get a disclosed package, there is no disclosed package. I bought the property, I fix, I sell. Could the buyer sue me, said, why you don't get a disclosed package when you buy the property?
Well, if if the seller to you was not legally required to give you any written disclosures, because if it was like a foreclosure or a trust sale or something, then you don't have any liability for that.
Okay.
So
Okay, great.
Yeah. We have to move on with other questions from other
Thank you.
attendees. You can maybe leave some of your questions privately to reach out to Simon. Yeah, or the chat box. So to continue about the statute of limitation, so basically as sellers, do they have to disclose pretty much like all the minor repair? This is a question from, I think, Lawrence, that have like such as removal of dead trees, irrigation system, everything they know that's done, they should actually disclose everything, right?
Yeah, well, there's no black and white rule on that. When I sold my last property, my disclosures were pages and pages long. You know, if I replaced a hose to my washing machine, I disclosed it. I have a target on my back because I go around teaching people how to do disclosures. So if I miss something, you better believe someone's going to be able to pull up a seminar I did and they say, you said you have to disclose everything. So I'm overly disclosing things for myself personally. It's a little bit of a balancing test. You know, if you're just replacing a sprinkler line, that's probably not something that materially impacts the value or desirability of the house. Lawrence said here about removal of dead trees. That's probably something that should be disclosed. And I'll tell you why. I have a case right now where the buyers purchased a property. The day after they closed escrow, trees were removed from the property. And they had no idea that was going to happen. And it turned out the trees were diseased. Well, when one tree is diseased, it's very likely that because there's some sort of beetle or whatever, the other trees in the property might also get diseased. And so there ended up being about 6 very significant trees that were all diseased, and they all had to be removed. And so had the seller disclosed that there's diseased trees on the property and we're going to, or we have to remove one, then the buyer's on notice that, okay, maybe I should have an arborist look at the other trees just to make sure they're okay. So there's no answer like, in this situation, yes, you have to disclose it. In this, you don't. It really is about gauging, is this something that materially impacts the value or desirability of the house? If you just have to change your garbage disposal, I'm probably not going to disclose that. But if there was a leaking pipe, I am going to disclose that because of those concerns I've got about how water damage things can actually have bigger impacts. So there is a balancing there, and I can't tell you exactly, do you have to disclose, certain things or not? It really is, what is the true impact of that repair or maintenance work?
Got it. Yeah. So another question, is the rental. So basically, John's question is as a landlord, sometimes, they have limited knowledge about the condition of the property because what's not occupied. So will they be exempting the landlord from liability when he tries to sell because he does not know all the issues regarding this rental?
I think adding that language that John mentioned here in the chat is a good idea to do. It doesn't necessarily guarantee that you're not going to get sued just because you put that language in, but at least puts the buyer on notice that you're maybe more of an absentee landlord because you don't live in the area or you don't live at the property, so your knowledge is limited. But if the tenant has told you something, or the tenant has made some sort of complaint, that case I told you about with the $300,000 worth of dry rot damage, the tenant had complained to the landlord about the water issues. So the landlord was aware of them and disclosed them. So if the tenants complained to you about things, you should be disclosing those. Maybe you don't believe the tenant, but if something that the tenant complained about actually does become a problem for the buyers, and then the buyers can prove that the tenant told you about that issue, you better believe the buyers are going to be suing. So there is no silver bullet to get you out of liability just because you're a landlord and you don't live there. It's helpful to have that language, but you've still got to do the best you can to disclose whatever you know.
Yeah. Got it. So another question from Kelly. Kelly said they bought a property within last few months, and then the neighbors show up and ask for access to the property for major construction. However, with the major construction going on, it led to significant damage to the property. So the construction required notification to neighbors, and apparently the seller did not disclose to them when they purchased it. And so right now, the damage is very significant, and the neighbor and the contractor are not willing to pay for anything, to ratify the situation on their own property. So can they hold the seller responsible for not disclosing about neighbors' upcoming construction project? And what is the statute of limitation for this type of lawsuit? Can it be a claim legal fee when they pay for the dispute with the labor from the seller?
Yeah. So, if the seller actually knew that there was going to be some major construction happening next door, that to me is something that materially impacts the value or desirability of the house, because now you've got to live next to a construction site for a year or more. And that's something that if they truly knew, they should have disclosed that. Now, the seller isn't going to be responsible for the neighbor causing damage to their property. That's between the then owner and the neighbor. But the difference between having a house that's quiet and doesn't have construction going on for a couple years versus having a house that does have that going on, there is some potential liability there for the seller. The statute of limitations on that is like I said, on the short end, if you're going to be making a fraud type claim, it can be as short as 2 years. On the long end, 4 years for breach of written contract. That being said, I always, want to go with the shorter time period and with the 2 years. And so, it's something that you want to move on sooner rather than later and not wait till the last minute. And the last part of the question is, can the legal fees with the dispute with the neighbor from the seller? So the purchase agreement between the buyer and the seller typically has an attorney fee provision in it, meaning that if you have to sue the seller and you win, you can claim your attorney's fees in the dispute as to you and the seller. If you're saying you're incurring legal fees to deal with the neighbor, those are a separate issue. And yes, you can argue that's part of your damages as to the case against the seller, but there's no direct contractual claim there.
Yeah, got it. Then another question is from Jane. Jane purchased a property from auction, and there was a swimming pool, and it's been filled with concrete. So in the future, if Jane sells this property, do they have to disclose whether the pool was done with permit, and they do not know if the work is properly done because it's an auction property?
Yeah, I would most likely simply be disclosing, and the caveat to all this is I obviously don't know all the facts, and so this is just my off the cuff analysis, but to get a real analysis I need to know more about all these things. But in general, if there's some work that was done and you don't know if it was or was not permitted, it's best just to say that, that the pool was filled by a predecessor. We have no details on how it was done and whether it was permitted. Buyer to investigate on their own, kind of thing. You don't necessarily have a duty to go out and investigate these things on your own. But if you have some question about whether it was done properly or with permits, you should disclose that and let the buyers go out and try to figure it out if they want to.
Yeah. So another question. So if any of the work done without permit, can the seller apply for permit before selling? And if the seller not applying permit at all and disclose it the way it is, like say how or what the buyer would typically ask for and how the seller would respond?
Yeah, so yes, you can try to get a permit for unpermitted work. The problem is that that can be pretty tough because, for instance, like if you put in a new bathroom, the city or the county needs to see the plumbing to make sure it was done to code. And that means they might need to open up walls in order to do that. So that can be very tough. So in those scenarios, if you just disclose that the work was unpermitted, you know, Monica, you might know better, or agents might know better, but in the Bay Area, it's so competitive that buyers might say, well, that's okay. If it's not permitted, we'll just have to deal with it if the county or the city comes and asks us to fix it. But, you know, so if you're disclosing it, then it's on the buyer to decide, is this a big enough deal for us to back out? Or are we okay taking the risk that it was done well? It helps to, if you have like an invoice or a contract from a contractor, to provide that, to see that, oh, okay, this was a licensed contractor that did the work. It was probably good enough. But if you just did it on your own, then it's a little tougher. So you just got to do the best to disclose everything you know. And then it's on the buyer to decide, is this something we want to take on or not?
Yeah. So we very often come across listing and say garage was converted and the seller is willing to convert it back to a garage before the close of sale. So there are different scenarios that the seller may handle. But like you said, in a very hot market, sometimes, the buyer would just take it as is and try to deal with it after the sale.
Right.
But as long as the seller discloses it, then the buyer knows what they are going in, right?
Exactly. Yep.
Yeah. So, okay, basically this another question about dimension. What if the house dimension and county record does not match the physical property? And so the county, say, shows 300 square feet less. I think you have mentioned briefly about like the size. Maybe you could want to address this again.
Yeah, so the square footage one's a tough one. You just have to disclose what you know. So it is common that the county records might be a little bit different from what's actually out there, because maybe someone did some improvements or converted a garage, like we said, or something like that to get the additional square footage. So you just got to disclaim where that information is coming from. The county says it's a 2,000 square foot property. We have an appraisal that says it's a 2,300 square foot property. And then you let the buyer figure it out from there. As long as you've disclosed those discrepancies, you've done all you can. Now, if you specifically know why there's a discrepancy, like we added on an additional room and we didn't get it permitted, so that's why the county says it's only 2,000 square feet. Well, you need to disclose that. But if you just don't know, which sometimes happens, I mean, with an old house, things might have changed over time. Just point out the difference and the discrepancy, and that's the best you can do as a seller.
Yes. As an agent, we always try to also put in private remarks and talking about like the difference if we know, and also we encourage the buyers and the buyer agent to conduct due diligence about the size of the property.
Yep.
And so if the seller's house, okay, this question from Lawrence, if the seller's house or the neighbors was burglarized or kind of having some other criminal acts such as sex offenders nearby, then do the sellers have to disclose?
Yes. So the disclosure documents specifically ask this question about criminal activity. Mm-hmm. So that should be disclosed. If you move into the property and a week later your house gets broken into and it turns out that the house next door had been broken into and the house across the street had been broken into, you better believe the buyer's not going to be very happy. So that does need to be disclosed. Sex offenders nearby, the contract, the California Association of Realtors contract specifically informs buyers of the Megan's Law database, which identifies, where sex offenders live. If you have specific knowledge though, like because there was a newspaper article that said a sex offender was moving in next door or something, you should still disclose that. you don't necessarily need to go on the Megan's Law database yourself and look for that. But if you know, then it should be disclosed. So absolutely, if cars have been broken into, if houses have been broken into, if there was a murder, you know, that kind of stuff needs to be disclosed.
Would that apply for a landlord to disclose that when they have a prospective tenant? Say if they are renting the house, that they know that like some car has been broken in the neighborhood before the tenant signed a lease. I know that there's, of course, you know, forms to talk about Megan database, Megan's Law database, but then how about like, say, for rentals?
Yeah, so it is best to do that because if something happens to the tenant's then going to say, you didn't tell me this and I want to break my lease and all that. There aren't as rigid of rules of how you disclose issues like that from a landlord's perspective. But it's always best to ultimately avoid liability and avoid upset tenants that want to break their leases, that if they knew about that and they signed the lease, then they can't really break the lease at that point.
Got it. Yes. So I have a recent situation that because it's such a quick rising market, you know, I have a seller who actually closed on a new home and they try to flip it because the seller's family does have like a job situation that they do not want to keep the house. So they flip it and try to make some money. However, because the closing of that home was not disclosed to the lender. Okay, when the buyer purchased it, he knows it's a brand new home that was like a back-to-back sale. But then the buyer and the buyer agent did not tell the lender that it's a flip. So the loan actually was sent to a lender that require what we call by seasoning. So a lot of Fannie Mae, Freddie Mac loans require 90 to 120 days seasoning. And so it did not work with the first lender, so they have to send it to another lender. So it ended up like the buyer was not able to close on time and the buyers require extension. But then because the market is moving fast and the seller declined to grant extension and the seller want more money. Not just a small money for the extension, like the PITI, you know, to pay for the mortgage, but they definitely want a lot more money, like 20K, 30K more. So can the buyer sue the seller?
Well, can the buyer sue the seller on what grounds? Because they didn't disclose that it had just been purchased?
Yeah, and it's just been purchased, did not make it clear. Actually, there's another scenario is when the buyer know that the seller does not want to close. And so he tried to actually get all the money into escrow to close it in cash. But then the seller declined to sign docs, even on the day that the contract expires.
Well, okay, so
would that be a breach of contract?
Yeah, if the buyer is able to close escrow, has the money in escrow, and they're still within the escrow period, and the seller refuses to sell, the buyer is entitled to sue for what's called specific performance. And specific performance means you have to sell me the property because you agreed to sell me the property. And so, you know, if the buyer didn't have the money in time and then the seller issued the demand to close escrow and the 2 days has passed and the buyer still doesn't have the money there, well, then the buyer doesn't have a right to buy the property anymore. But if they're still in contract, they haven't missed any deadlines, they've got the money there, just because the market's changed doesn't mean the seller can say, oh, I changed my mind, I want more money now. No, that's the point of a contract. So the buyer can sue for specific performance to have a forced sale of the property to them and for any damages they'd incur because of the delay in sale and the closing and their attorney's fees. It's a very simple specific performance case. So as long as the buyer can prove that they had the money there ready to go and the seller was just having a change of heart because he or she thought they can get more money, that's not a valid way to get out of a contract.
Got it. Yeah. Yeah. But otherwise, you know, like say, just not disclosing that it's a flip, then it would not be a ground because like the buyer actually know that they just closed on that new home.
Yeah, because if they knew about it and it's public record, you know, you can see when the house was bought. that's a tough one.
Yeah, yes. So like say when people selling flip, most of the time, you know, like say the agent probably know when they close the property by looking at the record. But then the seller also have to disclose that they close on this date, or do they not to have to? So that, you know, the buyer, when they look for loan.
I've never been confronted with that. When you bought a house, to me, isn't a material fact that impacts the value or desirability of it. So I don't see what duty there is there. Just because you bought it recently doesn't mean that it's worth more or less money.
Yeah, because sometimes it's only for financing. Right now with a government requirement, most of the time the flip, people would add value in it. They got a very kind of fix the upper and then do remodeling.
Right.
And then improve on it. And then they might disclose the work they've done. And then they close on it, maybe, you know, it could be like 60 days or maybe less than 90 days. But then if the buyer going to buy the house, you know, in terms of financing, some of the lender require seasoning more than like 90 or 120 days to be on the market. And unless, you know, like it can be proved that a significant improvement, because usually the price is going to be a lot higher. So that's why, you know, like such a situation arise.
The buyer should be either having a loan contingency where they find that out, or making sure that they can get the loan before they remove that contingency.
Yeah. But in this market, as you know, no contingency sale is very, very common about the situation. But you have been also dealing with cases about non-contingency sale that the buyer have remorse and try to come back with like for the claim for the earnest money or some of those. Did you do that often in this market?
We do those all the time on non-contingent offers, and then the buyer wants to back out, and who gets to keep the deposit. We have tons of those. That's a topic for another day, though. that's
yeah. I know. Yeah. It's going to be something that we probably want to discuss some other day. So I think we have finished all the questions today. Yeah, that's been very helpful. You know, we all learn a lot, Simon. Your experience and your cases that help many of the people who are planning to sell be more alert and vigilant when they try to prepare all the seller disclosure, and also help us as professionals so that we can help to do our service better, to protect the seller as well also the buyers. Very good. So
well, I appreciate it.
Wrap up.
For the opportunity.
Yeah, thank you so much. And for anybody who are interested to reach out to Simon for further question or need help, we have included Simon's contact on the screen, and we're going to send out the recording to everybody who attended today. And if there's any other real estate questions or needs, you can also reach out to me. Yeah, my contact is also going to be included in the email. Thanks so much, Simon, again, and wish you have a wonderful rest of the weekend.
Thank you. Same to you, Monica, and thanks for everyone for joining.
Thank you.
Thank you. Thank you. Bye-bye.
Bye-bye.